Good afternoon, and thank you for joining the Heritage Foundation's Tele Townhall meeting with Senator Jeff Sessions of Alabama and President Reagan's Attorney General, Mr. Edwin Meese, Chairman of the Center for Legal and Judicial Studies at the Heritage Foundation. My name is Robert Ault, Senior Legal Fellow and Deputy Director of the Center for Legal and Judicial Studies, and I'll be moderating today's call. Today we want to talk to you about the Senate confirmation hearings of President Barack Obama's second Supreme Court nominee, Elena Kagan. We also encourage you to visit our website, orderinthecourt.org. The Senate confirmation hearings for Elena Kagan are scheduled to start Monday. What will we learn and what should we watch for in the days ahead about what kind of justice Elena Kagan might be? We will explore these issues and more during the next hour. We thank you for joining the Heritage Foundation for our Tele Townhall. If you would like to ask a question, please press *3 and you will be directed to our operator. We also encourage you once again to visit orderinthecourt.org to get the latest news about Elena Kagan as the confirmation process unfolds. Now I'd like to turn it over to Mr. Edwin Meese. Mr. Meese?
Good afternoon. It's a pleasure for me to join in welcoming you to the Heritage Foundation's Tele Townhall. This session, of course, is devoted to the upcoming nomination for the Supreme Court, one of the most important tasks that any president has, because whereas other acts that he might undertake, executive acts, for example, can be undone by a subsequent president. Likewise, legislation he signs can be repealed or rescinded or changed by a future Congress. But the appointment of a judge to any of the federal courts, but particularly to the Supreme Court, usually lives on long after any particular president. And that's why this is such an important nomination that's under consideration today. Next week, the Senate will be meeting. The Senate Judiciary Committee will hold its hearing on Elena Kagan. Because she has had no judicial experience, because she's had very little litigation experience, because mostly as a Solicitor General in an appellate court, no trial court experience, and because there's very little in terms of her writing as a professor, it's going to be incumbent upon the senators to use the questioning in the Judiciary Committee to find out her understanding of the role of a judge, her understanding of her obligation, should she become a member of the Supreme Court, to follow the Constitution faithfully, her views on such controversial issues as whether international law should be used in terms of interpreting the Constitution. Can judges of the Supreme Court substitute their own ideas for what the Constitution actually says? Things such as this, which have been so important to Supreme Court interpretation of our founding document, as well as to its interpretation of the laws that Congress passes. So this becomes very important for the members of the Senate to exercise their responsibility to find out whether this particular nominee is qualified and will carry out faithfully her duty to protect, preserve the Constitution of the United States. And so that's why we're prepared to answer questions this afternoon about her, about the Supreme Court, and about the nomination process. With that, I will turn it back to Robert Ault.
Thank you, Mr. Meese. We will be joined very briefly by Senator Sessions, but in the meantime, we'll take our first caller. We have a question for Mr. Meese from Gary, who has questions about what's required to block a nominee. Gary, are you with us?
Yes, thank you for having this program, and I just wanted to know what is involved in blocking a nomination potentially, and do the senators have the courage, in your opinion, to do that, and do you see that might even be a possibility? Thank you.
Well, obviously to block a nominee, it takes a majority of the Senate, ultimately in the vote on the Senate floor, to vote against her. That means that more people would have to vote against her than vote for her, or at least have a tie. And then the tie, of course, then the President of the Senate, the Vice President of the United States, casts the deciding vote. So it really would take a majority of the senators voting to stop a nominee, or if there were obviously a majority of the Senate Judiciary Committee would vote not to vote the nominee out onto the floor of the Senate. Either one of those would stop it. There's one other way, which is probably not applicable in this case, and that would be to refuse cloture, that is to, in effect, filibuster a nominee. This has not been used for a Supreme Court candidate in a considerable period of time, if at all. So those would be the ways to block. I think the more important task of the Senate now is to delve into her background, her beliefs, her understanding of her role as a judge, and then if something develops as for a reason where she would not be qualified, would not have the proper judicial approach to the job, then that would be a reason to try to persuade members of the Senate to vote against her. And of course, I'm sure that there will be if you look at the experience of other nominees, there will be a considerable number of votes probably will be cast against her unless, based on what is known now, and unless there's some major changes. But whether that would be enough after that the Democrat Party has a considerable majority in the Senate, and so it would take quite a bit, really, and considerable evidence, I would say, to sway enough Democrats to get a vote against her.
Robert, Senator Sessions is on the call.
Senator Sessions has joined the call, and so at this point we will turn it over to Senator Sessions so that he can offer a few opening words. Senator Sessions, thank you for joining us.
Well, thank you very much, and it's great to be with Attorney General Meese, and I used to work for him, and he trained me in my legal philosophy in a lot of different ways. I think the American people overwhelmingly want judges who follow the Constitution as written, that they don't alter it to make it say what they'd like it to say, to promote their agenda, their politics. That's no place for that in a court of law. When you do politics in court, it's the antithesis of law, really. This nominee has less real legal experience than any nominee in the last 50 years. So really striking lack. She never tried a case, never cross-examined a witness, never stood before a jury. So that's troubling. She has been, however, very active politically in a few roles, political lawyer. But the essence of it is she has admitted to be politically active 5 years in the Clinton administration, for example. And she has very strong liberal views in a whole host of areas, whether it's guns, abortion, or socialism. She wrote a paper at college and seemed to lament the decline of socialism in New York. So those are matters that cause us to understand where her political agenda is. And the third factor that I think is toxic, or may be toxic for many people, would be the view that she has that judges have a right to advance the law. It's the correct thing to do, and that therefore this would empower her, I'm afraid, to believe that she can promote her political agenda through the rulings on cases that come before her, rather than conducting that, as John Roberts says, as a neutral umpire who doesn't take sides in a litigation. So I just say that to begin with, General Meese, and what's your suggestion as to how we proceed from here?
Well, Senator Sessions, it's great to be with you. A good friend and also an outstanding leader in the Senate and the ranking member of the Judiciary Committee. I know you'll have a leading role in the questioning of Elena Kagan when she comes before the committee next week. I think at this point we can go back to Robert Auld and take the next question.
Thank you very much, Mr. Meese. I'd like to remind listeners on the call that you can submit a question by pressing *3. That's *3 on your keypad, which will connect you to one of our operators. The next question comes from Theo Emery of CQ, who has a question for Mr. Meese. Mr. Emery, I'm here, yes. General Meese, how do you do? Question for you, sir. Would you mind expressing your opinion of General Kagan as a candidate? Do you support her candidacy? Do you oppose it at this point? And what do you see as being her potentially her strengths or weaknesses?
Well, I think it's important to reserve judgment until we see how she answers the questions before the Senate Judiciary Committee, before taking a position on whether she should be confirmed or not. I believe that her weaknesses are probably the fact that she has had no judicial experience, the fact that she's had virtually no litigation experience except a very brief time now as Solicitor General, and that she has very little that she's written as a professor, surprisingly so. So I think these are not only questionable marks, but also give rise to the need for increasing question by the senators. Her strengths, I guess, her strengths are the fact that she has had some experience as the dean of a law school, if that's a strength, and has had a very short experience working as Solicitor General, and has had a tour of duty in the Clinton White House, and that also may be one of the weaknesses, because there she was primarily involved in politics and political judgments, even though a member of the legal staff, but extensively got involved in political issues, and that could be both perhaps a strength, but more likely a weakness as the questioning proceeds.
So just to be clear, you're not taking a position on her nomination at this point?
At this point, I want to see how she answers these questions and see what the Senate Judiciary hearings produce.
Thank you, sir. Thank you. As well, once again, for those who are joining the call, please dial *3 if you would like to ask a question, and you'll be connected to an operator. The next question in the queue comes from Robert, and he had a question about partial birth abortion. Robert, are you there?
Yes, I am. I'd like to thank you for this opportunity from Texas, and I'm concerned about the position of Ms. Kagan's feelings on partial birth abortion.
The question is, what is her view on it?
Yes.
As I understand it, there was as I recall, I was involved in some of this, in the mid-90s, 97 or so, there was intense debate in the Senate to ban a partial birth abortion, and the majority supported that. It looked like there would be sufficient votes even to override a veto. It does appear that the Judicial amendment, which was offered by the Democrats, and Republicans accused the Democrats of just creating that as a cover vote to really not effectively ban that procedure, and give people a cover to vote against it. She supported that, and apparently was involved in writing that alternative, and in one of the memorandums seemed to indicate flat out that this was a cover vote, which was one of the disputed issues at the time. Was it a legitimate amendment, or was it a way to provide protection to people who wanted to vote against the elimination of that procedure? And I think she seemed to be very interested in the abortion issue, and seemed to have consistently taken that side, the pro-abortion side, in a lot of the matters that came up during that time. She'll get a chance to answer that, but that does appear what the record would indicate.
Thank you, Senator. The next question comes from Jackie Bradley. I did want to remind listeners once again that if you have a question that you'd like to ask either Senator Sessions or Mr. Meese, you can do so by pressing *3 and talking to one of our operators. Again, Jackie Bradley with a question about how she'll interpret the Constitution. Jackie, are you with us?
Yes. I was just wondering if she would be the type to follow the Constitution or try to change it.
Well, maybe General Meese could share some thoughts too, but I am troubled by the fact that three of her heroes in the judicial world, two being Judge Mikva and Justice Marshall, both of whom she clerked for, were two of the more activist judges, I think, that have been on the bench. And number two, the third person that she admires greatly was Aaron Barak of Israel, who is Judge Posner said is one of the most activist judges in the whole world and far beyond anything that we've seen in the United States. I just see a quote here from Judge Barak. He says that the way to bridge the gap between the law and life-changing reality is you can do that without changing the statute itself. He says, quote, the statute remains as it was, but its meaning changes because the court has given it a new meaning that suits new social needs, quote. So I indicated yesterday I thought that was letting the cat out of the bag of the activist philosophy, because that's exactly what they've been doing, is just taking a statute and altering meaning, and then they declare they're faithfully following what the Constitution says, but they've just given it new meaning. So she brought him to Harvard twice and has referred to him as a great, great judge who presided over the development of one of the most principled legal systems in the world. And it goes, Judge Barak's idea of judging goes beyond anything that we're used to in the United States, for sure.
Well, I would certainly agree with Senator Sessions on this subject, as when he mentions an activist judge. An activist judge is a person who essentially violates their oath of office and abandons the Constitution or abandons a particular statute as to what it was intended by the drafters, by the legislature that passed it, or by the people who ratified the Constitution or an amendment. And when they give it a new amendment, a new meaning, they're actually changing the law, which is solely the province of either the Congress in the case of a statute, or the people through their legislative representatives in the case of a constitutional amendment. Instead, an activist judge is a person who substitutes his or her personal beliefs, their policy preferences, or their political biases for what the law or the Constitution actually says. And if any person does that, then they really are doing something that is improper as a judge. And so that's why the questions to the Senate, or by the Senate, of this candidate are going to be particularly important. I think in view of the champions that she says are her heroes, all of them were extremely activist judges, and particularly Senator Sessions has quoted from Judge Barak. I think she's going to have to convince the members of the Senate that she disagrees with the pronouncements and the policies and the practices of her heroes.
And I would agree in the sense that I think that will probably be the defining, and fairly so, issue in this hearing. Will this nominee, young nominee, without much legal experience, but with a lot of clear political views, will she be faithful to the law and the Constitution as written, serve under it as her oath calls on her to serve, or will she follow the siren song of advocating her policies and bending the law to give it new meaning so it can say what she'd like it to say? That's an honest evaluation, and if the nominee can't convince the Senate that they're going to be faithful to the law, I think they should not be confirmed.
I would certainly agree with you, and I would say her case is made more vulnerable to attack in view of the fact that the president who nominated her, when talking about qualifications for a justice of the Supreme Court, talked about all kinds of things other than the fact that they would follow the law.
We have another caller. I just wanted to take a moment and remind folks who may have joined later in the call that if you have a question that you'd like to ask, you can get in the queue by dialing *3, and an operator will assist you. The next caller is James, who has a question as to the standard of questioning. James, are you with us?
Yes, I am. This is for Senator Sessions. Senator Sessions, I'm kind of a neighbor of yours. I'm in Baton Rouge, and I think you're from Mobile, if I'm not mistaken.
Right.
I have a question about the standard of questioning. There's been a lot of talk about the fact that this nominee does not have much of a paper trail. But in studying her background, I find she has a considerable paper trail in view of her academic writings, one of which is an extensive law review article in the University of Chicago Law Review about confirmation hearings themselves. And she admiringly speaks of the Bark hearings and the fact that Judge Bark in those hearings was required to state fully his views on philosophy and legal principles. She states that a lot of the hearings since then, and I'm looking at the article, without a meaningful discussion of legal issues, the confirmation process takes on an air of vacuity and farce. I'm just hopeful, Senator Sessions, that you and your colleagues will read some of these words back to her and press her not to backtrack from her own view of how the process should proceed.
Well, thank you, James. I think that's a good suggestion. I know we have already reviewed that law review article. It was raised to her when she came up for Solicitor General, and she made some statement, as I recall, indicating, well, of course, things have changed as she's moved along in years, but fundamentally, she was crystal clear in her views on that. And I do believe that since she doesn't have a proven record as a judge, any record as a judge, that it's fair to press her even more aggressively than maybe someone who can show and demonstrate that their rulings over the years have been faithful to the law. So you make a good point, and I think that will be raised at the hearing.
All right. Once again, for callers who wish to ask questions, please do dial *3. We have the next question in line comes from Sharon, who has a question about Clinton Library documents. Sharon, are you with us?
Yes, I'm here. I'm calling from Alabama, so Judge Sessions, you are my representative, and I absolutely love you. So I just wanted to put that in there. You're welcome. I have a few questions about this. I was wondering who makes the decision what the documents do get released and which do not get released from the Clinton Library and other places where she has records to look over.
Well, the library presides over the process. The library, of course, head is, I believe, selected by President Clinton, since it's the Clinton Library. His representative participates in review of documents, and President Obama's representative participates in the review of the documents. We saw an increase in the number of documents being withheld as the production came along. They produced about 160,000, but 1,600 apparently have been held back on the basis that it violates privacy matters, some of which could be legitimate, like health issues and things of that kind. But it is a troublesome thing that President Clinton, of course, has endorsed this nominee. She worked for him, and so did President Obama. So it's not as if that we've got an objective team evaluating those matters. Also, we issued, with Senator Leahy's concurrence, he and I sent a letter that requested all the emails that Elena Kagan had sent when she was in the White House and all she received, and all of them that mentioned her name. They have not produced those, the ones that are in which her name is mentioned. And we think that could be very important. It was a bipartisan request, and we need, I think that clearly should be produced.
Thank you, Senator. The next caller is William, who is asking a question that a number of folks have asked about related to the Clinton Library documents, about possible delays related to those. As I'm bringing William on the line, just a reminder to hit *3 if you'd like to join the conversation and ask either Senator Sessions or Mr. Meese a question. William, are you with us now?
Yes, I am.
Go ahead.
Senator Sessions, first of all, let me say that I appreciate your position, admire your stand, and I pray for guidance as y'all work in this situation, because the Supreme Court is critical to so many things that we're looking at in our nation today. My concern is, are you and other members that are concerned about Elena Kagan going to be able to delay the hearing until you feel that you have justifiably received the materials from the Clinton Library, and just as you mentioned, the emails, things that would be relevant to findings as to who she really is and what she would be as a Supreme Court judge? Do you think that y'all would be able to delay that hearing, or is it going to be out of your control?
It's pretty much out of our control. The date of the hearing is set by the chairman. If somebody challenges that, then a vote occurs, and the Democrats outnumber the Republicans 12-7 on this committee, which is the most disproportionate balance of any committee in the Congress. And so that's a problem. We believe that we want to, we're going to do our best to be prepared to go to the hearing Monday. I told Pat Leahy that. I told the President that. But I really believe it's rushed faster than was necessary. And we could end up with a real problem if as we go through this, we feel that deliberately documents that are clearly producible are not produced. I just hope that occurrence doesn't happen. Just delaying a week or so, I'm not sure means a whole lot. But this nomination is going to go forward. This president got elected. It's one of the consequences of a presidential election that they appoint judges. And I'm afraid he's clearly appointed one that's in his view of judiciary, which is not good.
I think it's important that the documents be made available, and I would hope that if the documents are not there to satisfy, and that some have been withheld so that the senators are not satisfied, that they would take action not to have a vote on this nomination until all of the documents that are needed are produced.
Before we go to another question from the callers, I thought I would take the moderator's privilege and perhaps pose a question to both the senator and Mr. Meese. For those who might have been in attendance here at Heritage or watching at heritage.org just prior to this event, we had a public event with Jeremy Rapkin and Carrie Severino talking about the role of international law, how it is that judges have been looking to foreign law to interpret the Constitution, the trend towards this, and what impact this might have on the Kagan hearings. Given her scant record, I was wondering your thoughts on role questions about foreign law might have in the hearings, and what we know about Kagan's views on foreign law.
The citation and reliance on foreign law by United States courts is so pernicious concept that I have no doubt it will be made a part of the hearings. People are going to ask about that. This Iran Barak that she admires so much from the Israeli Supreme Court believes it's regrettable that the U.S. Supreme Court does not make greater use of foreign law, and he's advocated that. That's one of her heroes. And so I'm definitely worried about it. The problem with studying a foreign law is plain if you think about it. Americans empower the government. The government has only powers Americans have consented to. They consent to it through the Constitution and through our statutes. and they didn't consent to foreign law. Americans didn't participate in drafting a statute in Europe or Sweden or Israel, nor did we participate in the selection of a judge who interpreted statutes there. And it's a undermining of democracy and the power of the people to give a lifetime appointed judge the power to search around the world to see if they can't find somewhere authority that would support their view. They're bound under our law and our Constitution.
I would certainly agree with Senator Sessions on this. As a matter of fact, I think that the use of foreign law as a means of interpreting the United States Constitution is, if not actually, certainly close to being an impeachable offense, because you're violating your oath of office, and that is to construe the Constitution and fairly and abide by the United States Constitution. And there's no place in that interpretation of our Constitution for the law of Zimbabwe or Rhodesia or any other country. So I think this is probably one of the key elements of the questioning that will take place.
Can I just add and ask General Meese, Greg Craig, who earlier was President Obama's counsel, on a TV interview said that, quote, Kagan, quote, is largely a progressive in the mold of President Obama himself, close quote. I know Heritage has done a study on the progressive movement, and maybe you would share historically, General Meese, how the progressives saw the U.S. Constitution.
Well, that's a very good point. Progressives are not progressives as the name would imply. It's the name that liberals use because the word liberal has become so disliked by the American people. The policies of liberals, the philosophy of liberals, it doesn't register well with the American people. So they now call themselves progressives, as they did, and this is a historical aspect to this, as they did in the early parts of the 20th century, the first 3 decades of the 20th century, and the so-called progressives at that time were absolutely opposed to the Constitution. As a matter of fact, they are quoted as saying they could do a lot in the government if it wasn't for that blankety-blank Constitution. And so that was the attitude of the progressives at that time, and I'm afraid it's the attitude of liberals calling themselves progressives today.
Well, on the subject of progressivism and elite views, the next question comes from Carol, who has questions about elite views on the court. Once again, I wanted to remind folks, if you'd like to ask a question, please do dial *3 on your phone, and you'll be able to ask a question to Senator Sessions or Mr. Meese. Carol, are you with us?
I am. You've already pointed out that we elect a president and he chooses the judge. I represent many people in the western states who feel that the decisions that are made by the judges they affect our lives, and yet we're not represented. We're represented only by Catholics, and our wonderful Jewish friends, and we have they're very elitist, very Eastern, and I just wonder, is there anything that we can do there? I'm not a racist. I love all people, but I think that the western states are not represented.
Well, Carol, you have asked a very important question that really goes to the heart of why we should not have activist judges, that is, judges who substitute their own ideas, their own experiences, their own the milieu, the society within which they move. And that's why the only way to have fair judging, fair to people whether they're in the West or any place else in the country, fair no matter what a person's religion might be, and that is if they stick to the law. If instead they substitute their own particular ideas, which is a function of their background, the people that they associate with, and so on, then we're obviously going to have unfairness, because the only way in which a judge can be fair to everyone is to follow the law and to follow the Constitution. So if you really put your finger on why it's so important that we have judges that do follow their oath and do faithfully interpret the Constitution and the laws that are before them.
That's a very good insight, and I would share that. And my number one question for a nominee is, will they be objective? Will they be fair? I remember that quote Sotomayor used one time. She said, there is no objectivity, just a series of perspectives. And if that's your understanding of what law is, and that objectivity is impossible, then that justifies judges imposing their own views. And I don't reject that. I think there is, we should be objective in handling cases, regardless of our own personal, religious, ethnic, or political views.
The next question from a caller comes from David, who has concerns about the Second Amendment. This, of course, is a very timely question. Listeners will note that it's anticipated that the Supreme Court will be issuing its decision in the McDonald case, which raises the issue of whether or not the Second Amendment applies against the states and not just the federal territories. That decision is likely to come down on Monday, the day that the Kagan hearings begin. David, are you with us?
Yes, I am.
Go right ahead.
Yes, I would like to know if Kagan gets approved for Attorney General, how would that change all the Second Amendment advocates and people who believe in guns and the Second Amendment rights?
I think it's raises serious questions. Her background is such that in the Clinton administration, and they were taking quite a number of aggressive anti-gun positions then, President Clinton-Gore administration, and she apparently was in the center of many of those issues. As a law clerk for Justice Marshall, she said she was not sympathetic to the right of a District of Columbia citizen to be able to maintain a firearm. And later, it took years later before the Heller case, by a mere 5-4 vote, held the right of an individual. The Second Amendment, instead the Second Amendment, kept the city of Washington, D.C. from denying gun rights. So this big vote coming up will now decide whether or not the Second Amendment applies to the states. And if they hold it doesn't, and then they would in effect say any state and any city in America could deny totally the right to keep and bear arms, because that right would not apply to them. It would be a huge issue of monumental proportions, and so we're watching with interest, and she will be questioned, I'm sure, about this, because she does have a record on it. And for those who believe in the Second Amendment, they would see her record as troubling, I think.
Yeah, I think that's certainly the case. And again, another reason why strong questioning is necessary. But I would hope that any nominee for the Supreme Court would be in favor of interpreting all the amendments to the Constitution, all the portions of the Bill of Rights, and not just selectively saying yes for some and no for others.
Our next question comes from Maria, who has some questions about health care. Again, if you'd like to be like Maria and ask a question to Senator Sessions or Mr. Meese, dial *3 on your phone and you can get in the queue. Maria, are you with us?
Yes, Senator. I'm very glad that this, as usual, the Heritage Foundation takes such an important step in helping the unheard voice of the American people. What I'm calling is because I do have, I was born in a country where socialism was the norm, and I have also lived in other European countries, and I know that what is being attempted right now in this marvelous nation is just totally wrong. The proof is that those countries are now renegating socialism. So my question is this: is there enough proof being prepared by our legislators to ask Mrs. Kagan to prove that this Ms. Kagan is a socialist? And we also, I'm also concerned because she could rescind on her philosophy of socialism because I have seen this happening among several public figures, changing their views when they get their own views get in the way for election or re-elections or nominations. For what I have read, she's not a person to change her ideas, her belief in socialism. So that is my question. Are you prepared with enough question that socialism that she sees as her philosophy for the best will be a good, strong reason for just not having nominated?
Let me say this. There's no doubt, indisputable really, that President Obama has expanded the role of government in ways people have not thought about before. The American people are very concerned about it, and they anticipate that a number of challenges, legal challenges, will be made to this expansive government that seems to be occurring before their very eyes and against their popular will. So we want to be sure that this nominee isn't somebody that President Clinton has nominated to sort of rubber stamp the agenda that he seeks to pursue, but will faithfully follow the Constitution and, if need be, strike down things that are unconstitutional. And you may know that when she graduated from Princeton, she wrote her thesis on the decline of socialism in New York. She wrote about all of that and basically expressed disappointment and some sadness, it seemed to me, in reading the paper concerning the decline of socialism. Whether that means anything today, she may well be inquired about that. But that was a paper that she wrote, I guess, as a senior in college.
I would certainly imagine that paper will be extensively discussed with her during the hearings, because as this caller indicates, the last thing we want, first of all, is a judge or justice who would violate her oath to put her own ideas in the place of what the Constitution says. But secondly, to do it in a way that leads this country into more socialism and more powerful government is directly contrary to what the founders had in mind, and directly contrary to the people, for the freedom of the people of the United States. So that paper and her ideas about it will be an important part of the hearings, I'm sure.
The next caller on the line is Barbara. She has questions about what it is that average citizens can do to be heard by their senators in the coming days. Obviously, one thing might be participating in a Tele Townhall. Barbara, are you with us?
I am. Thank you. Yes, I'm from Florida, and of course have been very active in writing letters and so forth to the senators throughout these various confirmation hearings on just about everything. And of course we get the standard phone letters back saying that, the president has the right to appoint blah, 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 or to nominate blah, blah, blah. And that's all well and good, but I mean, we have a lot of energy, but how is there any way for us to be more effective in the use of our energy, especially on something as important as the Supreme Court nominations?
Well, go ahead.
I hope that every American will follow this, and if they conclude that the nominee is given to the view that they can reinterpret the meaning of words and give them a new meaning so that they can advance new social agendas, that would be disqualifying, and that you would communicate that to your elected representatives. The Senate alone will vote, of course, not the House. So directing mail or communications to your senators does make a difference. I also think letters to the editor, call-ins to public forums like talk shows and so forth, all of these help shape and move public opinion. And I don't think the American people want a judge who will not be objective and who will not follow the law. Matter of fact, I'm certain they don't favor that kind of judge, and polling data shows it. and they would want to know, and people like yourself who keep up with it closely would be the kind of people that would alert the average voter that this nominee may be troubling, if that's what you conclude. And I think it's an important part of the democratic process.
I also wanted to pick up on the reply you apparently got from someone in either a senator or a congressman that the president has a right to appoint anyone he wants. I think the president takes an oath also to defend and protect the Constitution. And certainly, if a president appoints someone who is not going to uphold the Constitution, who is going to engage in substituting their own ideas for what the Constitution actually says, then, and the president knows that, then he's violating his oath of office. And for anyone to tell you that the president can just appoint anyone, that's not the case. And I would say that if an elected representative gives you that reply, then maybe it's time to change that representative next time they're up for election.
All right. Our next question, and this is one we've had a few different folks with this question, comes from Lisa, and it asks about what the process is for removal of a justice. Lisa, are you with us?
Yes, I am. My concern is that if she does get in, that what can be done to get her out, because I feel with her history, you mentioned the various things at Princeton and Oxford, and she has ridiculed this whole process, and and some of her decisions that shows that she is not following the Constitution, and the people that she associates with also are not following the Constitution, and they're gonna get her in, and then what recourse do we have to get her out? I feel her actions speak louder than words, and someone is not going to change overnight, lifelong belief systems and behavior patterns, and I feel that she would be a detriment. But if she does get in, what can we do to get her out?
Well, it's very difficult to get a justice off the Supreme Court, as history has demonstrated. Congress is reluctant to take such action as they can under the Constitution, and impeachment, I think, is the fundamental way, and that's very, very seldom done. So it is important to get the nomination right and the confirmation right. Maybe Attorney General Meese would add some thoughts to that.
Well, I would certainly agree with you that it's difficult. It's interesting to note that there have been more federal judges impeached over the years than any other federal public official. But in only a few of those cases were they actually convicted and removed from office. So it's very hard to do that. As you point out, the House of Representatives is reluctant to impeach, and obviously it's difficult to convict many times in the Senate. So I would say this is the time now to find out what kind of a judge we're going to get if she's confirmed, and take the action now to reveal what is probably going to be the case, and then to be sure that if in fact she cannot convince the members of the Senate that she is going to follow the Constitution, then she should not be confirmed.
Well, we are running close to the end of our time together. I believe that the last call we'll take, but I wanted to give the opportunity for both the Senator and for Mr. Meese to provide some closing statements. Senator Sessions, if you'd like to go first.
Thank you. I've enjoyed the conversation and the good questions that we've had. I take all of this seriously. As you can imagine, a lot of hard faith to form the right questions, and a good witness can ramble on and use up all their time and not say anything worthwhile. I do say fundamentally this, that every senator should be convinced that any nominee to the Supreme Court will faithfully serve under the Constitution and under the laws of the United States. They must not act above them. They're not able and not entitled to amend them or to alter them, to make the words say what they would like to say. and should indeed oppose and not confirm anybody who's not committed to that goal. So this will be the fundamental question, I think, as we go forward with the hearing. We'll do our best to elicit what kind of nominee this is in a fair way. She's entitled to a fair hearing, as any nominee is, but it's a confirmation process, not a coronation, and it should ask tough questions.
I would just like to add that, and certainly agree exactly with what Senator Sessions has said about the hearings and about the whole confirmation process. I'd like to thank all of you who have participated in this Tele Townhall, particularly those who asked such excellent questions. And just to say also in closing that I think our nation and its people are lucky to have Senator Sessions as the leader of the Republicans on the Judiciary Committee, the ranking member, to lead the senators in asking the probing questions and to do their very best to make sure that we get a justice who is worthy of this important appointment to the Supreme Court. So thanks to all of you for participating, particularly you, Senator Sessions, for participating in this Tele Townhall.
Thank you.
Well, I'd like to thank both Senator Sessions and Mr. Meese for their time and for what has been a very enlightening discussion about the Kagan nomination. I'd like to thank everyone who's taken the time to join this conversation, and particularly those who took the time to ask a question. For those who are following the confirmation process, we once again would encourage you to visit heritage.org and orderinthecourt.com in order to get orderinthecourt.org in order to get the latest information about the Kagan confirmation hearings. Thank you once again for participating, and we look forward to your joining us perhaps in the future for a Tele Townhall. Thank you so much.
Thank you.